Welcome. We're here today to talk with Carrie Brown, Executive Director for the Vermont Commission on Women, and Shirley Jefferson, Associate Dean of Student Affairs and Diversity, Title IX Coordinator, and Associate Professor of Law at Vermont Law School. Thank you both for joining us today. We're going to be talking about sexual harassment in the workplace. Before we begin, I want to note that while this conversation is focused on sexual harassment, the framework we are talking about can apply to other forms of discrimination, such as discrimination based on disability, race, or other protected categories under the law. These concepts are transferable and intersectional. Dean Jefferson, broadly, can you tell me what sexual harassment is?
While we often think of sexual harassment in isolation, sexual harassment is one form of sexual discrimination and involves treating someone differently based on their sex. Sexual harassment is prohibited in the workplace under state and federal law. This includes Title VII of the Civil Rights Act of 1964, which prohibits discrimination in places of employment that employ 15 or more individuals, and Vermont's Fair Employment Practices Act, which applies to any Vermont workplace, no matter the size.
Can you provide the actual legal definition of sexual harassment for the viewers?
The law defines sexual harassment as unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature, when that conduct affects an individual's work performance or create an intimidating, hostile, or offensive work environment.
When thinking about sexual harassment, the common perception is that it involves a man harassing a woman. Is that perception accurate?
Well, it's true that the most frequently reported type of sexual harassment involves men harassing women. Harassment can be between any two or more people. Sexual harassment can involve multiple people or be between individuals of the same sex. Under Vermont law, gender identity and sexual orientation are also protected categories, and harassment based on those characteristics is unlawful.
Over the past couple of years, as part of the Me Too movement, we've been inundated with headlines about sexual assaults and unwanted advances in the workplace. Are those actions considered sexual harassment under the law?
Well, while you have to look at the specific facts of each situation, unwanted advances or sexual assaults in the workplace would very likely fall under the legal definition of sexual harassment. But the definition does encompass much more than just the extreme cases we've been hearing about in the media.
What else does the legal definition cover?
Sexual harassment can be broken down into two categories of behavior. The first is quid pro quo, Latin for this for that. Quid pro quo sexual harassment occurs when an employer demands a sexual favor in exchange for a benefit in the workplace or in exchange for continued employment. This is a scenario where a supervisor may, for instance, tell an employee they will receive a promotion if they agree to submit to a specific sexual act.
And the second type?
The second type of sexual harassment is called hostile work environment. This is where conduct is so severe or pervasive that it creates an intimidating or abusive work environment that negatively affects the employee's job performance.
What does hostile work environment sexual harassment look like?
Well, hostile work environment can take many different forms. One example would be frequent sexualized comments about women and women's bodies that makes a female coworker feel targeted, uncomfortable, or demeaned.
A hostile work environment does not have to include sexual explicit comments. A hostile work environment can also be created where an employee is subject to demeaning behavior because of their sex, even if those comments of action are not sexual in nature. Either type of conduct can constitute hostile work environment, provided it is severe or pervasive.
I've heard that phrase, severe or pervasive, frequently when talking about sexual harassment. Can you explain what that means?
For a hostile environment to be unlawful, the conduct must be serious enough to create that intimidating or abusive work environment mentioned earlier. Isolated incidents or small annoyances cannot be serious enough to be considered a hostile work environment. However, one serious incident, such as an unwanted touching, may be sufficiently severe, even though it only happened once. Likewise, smaller annoyances, if happened frequently enough, may rise to the level of pervasive.
Let's talk best practice. What I'm hearing you say is that the law only prohibits conduct that has reached the severe or pervasive threshold. Does this mean that employers must allow workplace conduct that is not severe or pervasive?
Oh, no, absolutely not. Employers can and they should create workplace policies prohibiting certain conduct in the workplace. These policies can prohibit sexualized behavior, comments, or actions, even if that conduct's not severe or pervasive. So by not accepting this type of conduct at all, employers can prevent it from reaching the level of seriousness required to fall under that narrow legal definition. And more broadly, employers can also set workplace expectations and create a workplace culture where certain behaviors are simply not tolerated. It's always wise for employers to convey and expect a workplace culture where any kind of offensive or unwelcome conduct is not acceptable or appropriate, whether it's sexualized or not.
What is an employer's legal obligation if it becomes aware of sexual harassment in the workplace?
If an employer becomes aware of sexual harassment, they have the duty to investigate the conduct and to make it stop. The standard is known or should have known. So turning a blind eye will not relieve the employer of its duty to make the conduct stop.
You mentioned the employer's duty if they become aware, but who are we talking about specifically when you say they? Any employee or only the company president?
Employers are vicariously liable for the conduct of their supervisors. This means that in certain situations, an employer can be liable for harassment carried out by a supervisor, even if the victim does not report the harassment. If we're talking about harassment that occurs between two co-workers, neither of whom are supervisors, the law requires that a supervisor knew or should have known about the behavior for the employer to be held liable.
Okay, so if a supervisor is aware of harassment, either because they're the harasser or they're aware that the harassment is going on, then the employer's duty to investigate kicks in?
Correct. There are almost two important pieces to note when we're talking about knowledge of harassment. First, knowledge does not always mean a direct report of harassment. It may mean that a supervisor sees or overhears the harassing behavior. Second, we are talking about any supervisor. So if you're a manager or someone from a separate division or work team member come to you with a complaint of harassment, that still constitutes employers' knowledge and need to be addressed.
Under Vermont law, supervisors can be held personally liable for harassment. So this means that if a harassment case goes to court, the supervisor could be individually liable for any resulting damages. It's critical that supervisors understand their obligation to address harassment in the workplace and that they take that obligation seriously.
What about if the supervisor is the harasser? Where should the employee turn?
An employee can choose to report the harassment to any other supervisor or to someone in human resources or to anyone else in a management or supervisory role. If the employee is not comfortable with the internal options for reporting they have, they may choose to report to various law enforcement agencies, including the Equal Employment Opportunity Commission, the Vermont Attorney General's Office, or the Vermont Human Rights Commission. These agencies have the authority to investigate claims of sexual harassment. They can also answer questions an employee may have about the law and point employees to other resources.
What about the employee's obligation to report sexual harassment?
The law does not require that employees report sexual harassment to their employer. They are free to go straight to law enforcement if they so choose, or if not, to report it at all. However, if an employee does not report the harassment internally, the employer has the defense of not knowing that the harassment was occurring. This means that the employer may argue they could not do anything to stop the harassment, since the employee never told them it was going on.
What should an employee do if they witness harassing behavior in the workplace, but someone else is the target of the harassment?
Well, as mentioned earlier, supervisors have an obligation to address harassment that comes to their attention, either by reporting it up the chain in management for appropriate action or by addressing the situation directly. But if an employee is not a supervisor, witnessing workplace harassment can be a little more challenging. Employees have several options. They can choose to address the harasser directly. They can go to the victim of the harassment and offer their support. They can also choose to report the harassment themselves. How to best handle a bystander situation will depend on the individuals involved and the type of conduct witnessed. My organization, the Vermont Commission on Women, has put together some useful guidance for bystanders who witness sexual harassment. And this guidance can be found at our website, which is at women.vermont.gov.
What if the witness approaches the victim of the harassment, but the victim does not want to report the issue?
This is a common scenario. It's up to the employee who witnessed the harassment how they choose to proceed. They may choose to report the situation regardless of their coworker's wishes. They also may choose not to report and honor the coworker request. In that case, the employee may decide to document or take notes on what they saw, should the issue escalate or happen again.
Does the employer's obligation change if an allegation of sexual harassment is brought forward by someone other than the victim, or the victim does not wish to have the harassment investigated?
No, this is a common misconception. An employer must still investigate even if the complainant does not wish for this to happen. While it may make the investigation more challenging, an uncooperative victim does not excuse the employer from its obligations under the law.
We've talked a lot about procedures for reporting sexual harassment in the workplace. Is there any legal requirement in terms of policies employers must put in place?
Under Vermont law, all employers must adopt a policy against sexual harassment and provide that policy to their employees. This policy must explain that sexual harassment and retaliation are unlawful. The policy must also provide examples of what constitutes sexual harassment. It must also provide information about who to contact for the law enforcement agency that enforces discrimination laws. If an employer has more than 5 employees, the policy must include the process for filing an internal complaint of sexual harassment and include the name of the appropriate internal contact person responsible for filing complaints of sexual harassment.
And who should that contact person be?
That's up to the employer. Best practice is to have the contact person in the policy be someone who's seen as available and accessible to employees. It is critical that the point person understand the laws around sexual harassment and understand the employer's own policies so that they can act accordingly. This contact person should not be the company president or head of the organization simply because of their position. So while the top leader certainly has the duty to address harassing behavior they become aware of, they may not be the most appropriate or accessible resource for employees.
The policy requirements you just mentioned only reference employers. What does this mean for independent contractors or other workers who are not traditional employees?
Well, in 2018, the Vermont legislature expanded the state's laws around sexual harassment to protect all persons who perform worker services. So this means that if you engage a person to perform work on your behalf, you have an obligation to ensure that working relationship is free from sexual harassment. Under Vermont law, a business who may have both employees and contractors working for it is required to protect all of those people from sexual harassment while on the job.
It's not uncommon in sexual harassment matters to hear about blaming the victim. Can we talk about what that is and how to handle those situations?
Great question. The existing legal definition of sexual harassment includes a requirement that the conduct be unwelcome. Because of that, a common legal defense is that the complainant welcomed the conduct. Unfortunately for employees, this can feel like they are being blamed for their role in the situation, and in some cases prevents individuals from reporting sexual harassment.
So apart from legal definitions, in striving to create a workplace free of harassing behavior, employers should encourage a culture where employees feel comfortable drawing the line and telling coworkers when they find their conduct offensive, even if that conduct doesn't meet the legal standard of harassment. Employers should also acknowledge and appropriately address employee concerns regarding offensive conduct, even if the conduct's not severe or pervasive. Promptly handling these situations will allow employees to trust that their employer takes complaints seriously. This can also help create a culture where voicing concerns is respected and encouraged.
Another common theme that I've heard is that victims of sexual harassment do not come forward because they're afraid of retaliation from their employer. Can you talk to me about the prohibitions against retaliation?
Both state and federal law prohibit retaliation. This means that employers cannot punish an employee from complaining of discrimination.
Does that mean an employer cannot fire someone for reporting discrimination?
Yes, retaliation can take the form of a termination. Retaliation can also take many other forms. It includes an action that might deter an employee from complaining about discrimination or harassment in the future. This is referred to as a conduct that might have a chilling effect on reporting unlawful behavior. Retaliation could include demoting someone, transferring someone to an office further from their home, or giving someone less preferred job tasks. It can also mean threats or verbal abuse.
Are there any protections against retaliation for someone who reports harassment, even if they were not the victim?
Yeah, the protections against retaliation are broad, and they cover anyone who reports harassment. These protections also protect employees who may be witnesses to the harassment or who are asked to participate in any investigation of a claim of harassment.
Another common concern that I've heard regarding reporting workplace sexual harassment is the individual's fear that if they report, everyone will know, and that they will develop a reputation or lose friends. What can employers do to lessen this fear?
This is a tricky issue. Employers cannot promise absolute confidentiality in their investigation for a couple of reasons. To adequately investigate in a complaint, an employer will need to speak with other people who may have witnessed the harassment. To conduct a proper investigation, others will need to know that a complaint has been made.
What about those other witnesses, though? Can the employer require those employees to keep any information learned confidential?
In most circumstances, employers cannot demand confidentiality in conducting an investigation. The National Labor Relations Act requires that employees be allowed to discuss terms of conditions of employment. Courts have deemed that this includes ongoing disciplinary investigations. However, employers can explain the negative impact workplace rumors and gossip may have had on the workplace. Employees investigating workplace harassment should remind all witnesses that retaliation is against the law. This protects both witnesses and complainants from retaliation.
I've often heard that after a complaint of sexual harassment is brought forward, the employer refuses to fire the person accused of the harassment, even if the allegations have been substantiated. What can victims of harassment do if this is the case?
As discussed earlier, the legal requirement is that the employer, once aware of the harassment, investigates and makes it stop. So if the employer has effectively made the harassment stop, the person who reported the harassment does not have much recourse. They do not get to choose the employer's manner of handling the complaint or whether the harasser remain employed.
If an employee is in this situation, they should be open with their employer about any behavior that makes them uncomfortable. They should promptly complain if the harassment continues or if they experience any behavior that may appear retaliatory. Maintaining these open lines of communication and trusting relationships are key to maintaining a workplace culture that handles harassment situations appropriately.
We've talked a lot about the employer-employee relationship and internal reporting mechanisms. What other resources might be out there, both for employers and employees, when dealing with issues of workplace sexual harassment?
Well, one often overlooked resource is employee assistance plans, or EAP. EAP programs can offer confidential support for managers, victims, bystanders, and employees accused of sexual harassment alike. They can talk individuals through how to handle challenging conversations and how to determine what conduct is actionable. Employees who are dealing with workplace sexual harassment can also always contact law enforcement, either if they believe their employer has not handled the issue appropriately or if they're afraid to come forward to their employer. Employees in private employment can contact the Vermont Attorney General's Office Civil Rights Unit. State employees should contact the Vermont Human Rights Commission, And then all employees in Vermont can also contact the Equal Employment Opportunity Commission, which is the federal body responsible for enforcing employment discrimination. These entities can answer questions about sexual harassment law, and they can also investigate complaints of harassment and discrimination. And employees should also keep in mind that in some instances, sexual harassment can actually amount to assault. If that's the case, they're strongly encouraged to contact their local police to report the conduct. Law enforcement can also connect employees with victims' advocates who can provide valuable resources and support.
I want to thank you both for providing valuable insight on this topic today. It's been very informative. And thank you all for watching. If you have any questions about this video, please contact the Vermont Attorney General's Office Civil Rights Unit.